Hello and welcome to Research Academy's YouTube channel. Today we will be talking about the 5 most important case laws for family law if you're preparing for CLAT PG 2024. We have previously made videos where we have discussed important case laws from constitutional law and criminal law. So please check out those videos as well if you're targeting CLAT 2024. So before we start, we have a quick announcement. We have launched the CLAT PG prep kit, which includes the casebook and the mock book, which can come very handy if you're preparing for CLAT PG because it will help you prepare for case laws faster, and it will also give you an opportunity to practice mock test on the recent pattern. You can buy this from the link given in the description box and from the link on your screens. Now coming to the family law cases, the first very important judgment has been the case of Revan Siddappa versus Mallikarjun. It's a 2023 judgment. Now this is a 3-judge bench decision, so it is a very important case. This judgment is on the rights of a child which is born out of a void or avoidable marriage. So as you guys know that section 16 of the Hindu Marriage Act talks about the legitimacy of such children. So the court has clarified that with respect to the rights in property, a child which is born from a void or avoidable marriage will be entitled to the parents' share in the Hindu undivided family as well, which is governed by the Mitakshara law. The court has, however, clarified that the child will not be treated as co-partner by birth, but he will definitely have a right to the parents' share in the HUF. So while you are reading this judgment, also read section 16 very carefully, because section 16 is the section which provides for a deeming fiction, which assumes that children born out of void or voidable marriages will also be legitimate children. So this is a very important judgment and very likely to come in your CLAT examination. Now coming to the second case, we have the judgment of Shilpa Sailesh versus Varun Srinivasan. This is an extremely important constitutional bench decision. In this case, the court has clarified the long-standing debate with respect to usage of Article 142 in matrimonial matters. So court has made 2 very important findings. First finding is that the waiting period, the minimum waiting period of 6 months under section 13B clause 2 of Hindu Marriage Act, which deals with mutual consent divorce, that period can be waived by the Supreme Court under Article 142. While deciding this, court also referred to a 2017 decision in the case of Harmanpreet Kaur. In that case also, the Supreme Court has held that this waiting period is actually not mandatory, but it is only directory in nature. So in this case, the court has once and for all settled the issue that while exercising the power under Article 142, Supreme Court may, if it thinks is right, may waive the waiting period given under section 13B as well. Now coming to the second very important finding of the constitutional bench decision, the court has held that divorce can be granted on the ground of irretrievable breakdown of marriage under Article 142. Now the Supreme Court in the last 10 to 15 years have been using this ground and has been using this power under Article 142 to give divorce, because statutorily divorce on irretrievable breakdown of marriage has not been recognized under the Hindu law. So therefore the court has reaffirmed both the things and the usage of Article 142 in such matters. So you can see that this is a very important case, and this is the area which has also not been tested in the last 4 to 5 years. So this has a very strong possibility of coming in your exam. Now coming to the third judgment, we have the case of Ashwini Kumar Upadhyay versus Union of India. This is a 2023 case. It's a 3-judge bench decision. The judgment is very short because the Supreme Court has refused to entertain the PIL. So the judgment does not really have much in it. But the topic on which this case is, that topic in itself is very important. So in this case, a PIL was filed which asked the Supreme Court to increase the marriageable age for girls from 18 to 21 years. The Supreme Court dismissed this PIL because the court was of the opinion that making changes in the marriageable age is the domain of the legislature, and the courts cannot intervene in this matter in the PIL jurisdiction. So even though the judgment is very short, the issue is important because for this you will have to read the issue of child marriage and whether child marriages are void or valid or legal or illegal under the Indian laws. So you will have to have a good understanding of the Hindu Marriage Act, the Muslim law on marriage, and also the Prevention of Child Marriages Act to understand the legality of child marriages in India. So this is the next important judgment that we have. Now coming to the fourth case, this is also another Ashwini Kumar Upadhyay versus Union of India case. This was also in the form of a PIL, which was again rejected by the court. So in this 3-judge bench decision, the PIL was to enact a gender neutral and religion neutral law, which the Supreme Court rejected because again, separation of power. The court acknowledged that having a uniform law or a gender neutral or a religion neutral law for everybody is the domain of the legislature, and this can only be done by way of making a law, and the court cannot interfere in this matter under the power of Article 32 or its writ jurisdiction. Now while you are reading this very short judgment, make sure that you read on the issue of Uniform Civil Code, read about Article 44 of the Constitution of India, and also read about the landmark cases on UCC in which the Supreme Court has time and again raised a requirement for a UCC in India. So you can particularly place focus on the cases of Shah Banu Begum, Sarla Mughal versus Union of India, and Lily Thomas versus Union of India, because all of these cases talked about the issue of Uniform Civil Code. Now coming to the last judgment, which is very important in family law, we have the case of Kamla Neti versus Special Land Acquisition Officer. Now this is a 2022 judgment. It's a 2-judge bench decision, but it is on a very important aspect of Hindu Succession Act. Now if you guys are familiar with Hindu law, you would have seen that section 2 of all the Hindu laws talks about the applicability of the Hindu law. So if you read the clause 2 in those laws, you will see that it exempts scheduled tribes from its applicability. The only catch is that if the central government by way of a notification covers any scheduled tribe within the ambit of Hindu laws, only then they will be covered, otherwise they are not covered under the Hindu law. So similar position exists in the Hindu Succession Act as well, in which section 2 clause 2 exempts scheduled tribes from being covered from HSA. So in this case, since the issue of property was relating to a scheduled tribe woman, the court held that a scheduled tribe woman will not be entitled to any right of survivorship, which is otherwise available to women under the Hindu Succession Act, because scheduled tribe women are not covered under the ambit of HSA. So while recognizing this, the Supreme Court was of the opinion that this is how, although this is legal as of now, but this is unfair, and the protection of Article 14 should be available to all women, and even scheduled tribe women should be covered by this benefit under the Hindu Succession Act, and that is why the Supreme Court has urged the centre to bring a suitable amendment. So you can see that the last 3 cases were very short, but they are on important conceptual issues for which you should be prepared for. So this brings us to the end of our 5 important cases on family laws. If you like our content, please like, share and subscribe to our channel. And if you want more such content, leave them in your comment section.